ahead. So today is Wednesday, June 17th, 2020, and this is a time and place for the hearing examiner's hearing for docket number 2020-016, cause number 132-03, in the matter of request for agency action of XCL Resources, LLC, for order pooling all interests, including compulsory pooling of the interests of certain non-consenting and unknown owners within a 1280 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Colton formations, comprised of Section 26 and 35, Township 2 South, Range 2 West, U.S.M Special Meridian, Duchesne County, Utah. My name is John Rogers. I'm environmental manager at the Utah Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner of this matter. I will be represented by from the Attorney General's office, and the division is represented by
Haley Silva for the division.
And the petitioner?
Mitch Mayo on behalf of XCL Resources.
We'll proceed with Mr. Mayo and his opening remarks.
Sure. Thank you, Mr. Rogers, for having us here today and for acting as hearing examiner. As I said, Mitch Mayo of Lear & Lear PLLC, appearing on behalf of XCL Resources today. With me today are Kevin Ananson, Vice President of Business Development and Land, and Josh Sigler, Vice President of Geology, both with XCL Resources. I'd like to let everyone know, just remind them that I have my cell phone on in order to communicate in case there's a need to communicate with my clients. So I apologize in advance for any interruptions. Could we please have the witnesses sworn in at this time? Oh, yeah. You know what? Actually, before I do that, I apologize. We identified one third exhibit. He's on the call here, Mark Gravy. We don't anticipate to use him as an exhibit, but it might be wise to swear him in the event we need him during further discussions.
Okay, Mitch, that'd be a good idea. Let's do that.
Thank you.
Will each of you raise your right hands? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Sigler, do you swear? I didn't hear your answers.
Yes, I do. This is Kevin. I do.
This is Mark Gravy. I do.
Okay, thank you.
Michelle, was that sufficient? We're okay there?
Yes, we're good.
Okay. Thank you. Before we begin, XCL would like me to thank the division staff and IT staff for putting this together and making this a reality in these crazy times. As I stated, the resumes of Mr. Ananson and Sigler have been submitted as Exhibit A, as has the resume of Mr. Gravy, all of whom have been sworn in as witnesses. The resume of Mr. Gravy has been submitted as an abundance of caution, and he is not intended to be called as a witness today. However, he's available depending on where the conversation goes, should we need his expertise. Mr. Evans, oh yeah.
What is his expertise? What is
well, Mr. Gravy, why don't I let you explain your background with XCL real quick?
Yes, sir. So I lead XCL Resources regulatory planning and reservoir engineering. Background is 10 years unconventional resources and major shale plays across the country.
Thank you. Yeah, and Mr. Rogers, just to clarify, if we do call him, we will qualify him if he's planning to give expert testimony.
Okay, thank you, Mitch.
You're welcome. Mr. Ananson and Mr. Sigler have both appeared before this board, most recently in April in docket 2020-007, cause number 602-01. In that cause, as in this cause, Mr. Ananson was a fact witness and Mr. Sigler was qualified as an expert in geology and development operations. Assuming with stipulation of division counsel, I'd like to have Mr. Sigler admitted as an expert in those same fields here at this hearing.
The division doesn't object to that.
Okay.
Okay.
Thank you. Also, as a standard practice, I'll be moving for the admission of our exhibits at the end of our case in chief.
That'll be fine, Mitch.
Okay. This, as you stated, Mr. Rogers, this cause involves a single two-section 1280 drilling unit covering sections 26 and 35 of 2 South, 2 West. I will sometimes refer to that as the subject lands. There have been 2 wells drilled on these lands, and those 2 wells, as you said, target production from the Lower Green River-Wasatch, Colton formations, which will sometimes be referred to as the subject formations. The drilling unit was established by the board in September of 2016 in cause number 139-140. Without getting into too much detail, that order allows for the drilling of various number of long lateral, short lateral, and vertical or directional wells to be drilled and produced from the subject formations. A true and correct copy of that order has been submitted as Exhibit B in this cause, but we do not intend to address that order any further in this hearing. Feel free to ask questions should you have any about that. Relevant to this hearing, XCL has drilled, as I stated, the 2 following wells: the Butcher Butte number 35-64H-22 well, and the Butcher Butte 35-104H-22 well. These are each 2-mile horizontal wells producing from the subject lands, sections 26 and 35. There is only one working interest owner in the drilling unit who has not yet made an election to participate, and that is Robert L. Bailiffs Producer, LLC, who has about a 1% working interest in the drilling unit. In addition to Bailiffs, XCL seeks to force pool to the extent necessary the estates identified in Exhibit 2 attached to the request for agency action. XCL believes that all of the owners of an interest in those estates have been voluntarily joined into the well. However, because we have not seen, they have not been probated, or we have not seen the probate documents, we can't conclusively determine that. So out of an abundance of caution, these estates have been included in the request for agency action, and notice of the pending action has been provided to any unknown heirs or devisees by publication. Affidavits identifying these published notice have been included as Petitioner's Exhibit L in this cause, filed last week. No owner has responded, no owner from the estates, I should say, has responded or paid its portion of well costs as a result of those notification efforts. Because no interested parties have timely objected to this request for agency action, pursuant to Utah Administrative Code Rule R641-104-150 and R641-108-400, we would move to enter default against them. We would like to note, however, that on June 10th, 2020, Robert L. Bailiffs Producer, LLC, which I may sometimes refer to as Bailiffs for simplicity, filed a comment letter in this cause. We will discuss that comment letter during Mr. Annenson's testimony today. In sum, XCL seeks to force pool Bailiffs and the estates to the extent necessary. XCL seeks to apply terms of the JOA and the acreage-weighted average landowner's royalty, as shown in Petitioner's Exhibits G and J, respectively. The terms of the JOA have been determined to be just and reasonable by the board in past hearings, most recently by the hearing examiner here today, Mr. John Rogers, in April of 2020. Finally, the board has jurisdiction over this cause pursuant to Utah Code 40-6-6.5. The testimony and evidence presented will establish that the regulatory and statutory requirements have been met to deem any unleased and uncommitted working interest owners as non-consenting parties, as those terms are defined in the relevant law. Before I begin with my examination of Mr. Annenson, I would like to make an oral motion on the record, Mr. Rogers, to strike Bailiffs' request contained in their 610 comment letter. Specifically, Bailiffs respectfully requests that the board adopt their JOA revisions or artificially limit application of XCL's proposed JOA. Bailiffs also requests specifically that the board ask certain questions of XCL on Bailiffs' behalf. These requests are inappropriate under Utah Administrative Code Rule R641-102-200, which requires a company to be represented by a licensed attorney in Utah to seek affirmative relief from the board, and also Utah Administrative Code Rule R641-105-100 at SEC, which requires that a party seeking formal relief from the board file either a response or a motion. Because Bailiffs' comment letter is neither a response nor a motion and is not submitted by an attorney licensed in Utah, we would ask that those requests be stricken and that the comment letter, the bulk of the comment letter, be treated as a comment letter.
Mr. Mayo, at this time, I'd like to counsel with my attorney.
Sure.
So could you give us maybe a few minutes and we'll, and then I'll be right back. So I hate to.
That's
stop
okay.
right now, but I knew this would be coming up, so. I'll be
Perfect.
speaking
Thank
to
you.
him.
Okay.
Okay, I'm back.
Yes.
I would like to ask the division and their counsel their feeling on this matter.
Thank you, Mr. Rogers. So the division understands that the request is going to the board, and the division also understands Mr. Mayo's request that the board consider the comment letter to be just that, a comment letter, and ask the board not to ask these questions. But the division is going to reserve the right to ask these questions should the division think that these should be addressed during the course of Mr. Mayo's presentation.
Okay, Mitch, can we put that decision aside until we hear from the division and their presentation?
Well, absolutely. And maybe I should clarify. I would like to move to strike them from Bailiffs' comment letter. Of course, I can't and wouldn't try to preclude the division from doing anything it needs to do in this hearing to pursue its client's objectives. So it's maybe formalistic, but it is important that parties are held to the rules. That information is out there. If the division would like to ask questions, that's absolutely appropriate. It's just not appropriate to make informal requests in a comment letter.
Okay, noted, and we'll proceed, and then we'll make that decision once we hear from the division.
Okay. Okay, with that, I'd like to begin my examination of Mr. Ananson. Kevin, are you there? Hey,
Can you hear me now? I'm sorry.
I can, yeah.
Perfect. Yep, I'm here.
Will you please begin by stating your name and business address for the record?
Yep, Kevin Annenson. I am the VP of BD and Land at XCL Resources. Our address is 3217 Montrose Boulevard, Suite 200, Texas 77006.
Okay. And
Can
Michelle,
I-
are you? Oh, sorry.
Yeah. I'm just, he's getting a little garbly. I don't know if they can get closer to the mic.
I want to pull this up a little bit and you can zoom out. Yep, one second. There. Might want to check the video. I think I kind of turned it a little bit. Is that better?
It's a little better.
Okay.
Okay.
I'll talk a little bit louder.
Would you like him to repeat those answers, Michelle?
Yes, please.
Okay.
Sure.
Kev, can you please also spell out your last name when you say it, just so she can get it in the record?
Of course.
Thank you.
Kevin Annenson. That's Annonsen. I am the VP of Business Development and Land at XCL Resources, and our address is 3217 Montrose Boulevard, Suite 200, Houston, Texas 77006. Is that better?
Yes, thank you.
Thank you. And are you assigned in your role as Vice President of Business Development and Land? Are you assigned to these wells that are issued today?
I am.
Okay. And do you exercise a supervisory role in that position over the land records associated with these wells?
That's correct.
Okay. And will you please provide the corporate and bonding status for XCL?
Sure. XCL is a Texas corp, and we're in good standing, having its principal place of business in Houston, Texas, and we are fully bonded with all.
Okay. And I'd like to start by turning your attention to some exhibits, and I'm going to start presenting and screen sharing now. Let me
Go see his screen share.
It is taking a moment. And I am not certain why, but it is not letting me share my screen. So let me try and adjust one setting really quickly and I'll be back. Okay, I apologize for that. It still is not letting me share my screen. And I don't know. Let me try a window and see if that's better. Okay, can everyone see that?
Yes, sir.
Yeah.
Okay. Kevin, first I'm going to turn your attention, if I could, to a couple of exhibits just to help orient the Mr. Rogers to kind of where we're discussing today. I am going to try and do this as large as possible, so there's going to be some back and forth, but bear with me. Exhibit 31, Exhibit C, Exhibit D, and Exhibit E. Do you recognize these exhibits?
I do.
And were they prepared by you or under your direction or supervision?
Yes, that's correct.
Okay. Exhibit C, will you just help orient Mr. Rogers to where we are in relation to other landmarks in the basin?
Yeah, sure. So what this is, it's a general locator map. And as you can see, we've got outlined in the red dashed lines the subject lands, which is in 2 South, 2 West, 26, and 35. And you can see the city of Roosevelt right over there to the northeast of these subject lands.
Okay. So the subject lands are 6-7 miles southwest of Roosevelt.
That's correct.
Okay. And turning to Exhibit D, and really this portion of Exhibit D, can you tell Mr. Rogers what this is?
Yeah. So this is a unit mineral tract plat for 26 and 35, and what it shows is how the ownership is broken out by each tract.
Okay. And how did you determine this tract breakdown?
So we get a division ordered title opinion that was prepared by an attorney, and this was done by the firm of Lear & Lear.
Okay. And when was that title opinion completed?
April 13th, 2020. Excuse me,
Okay.
April 24th, effective as of April 13th, 2020.
Okay.
I'm sorry, will you repeat that answer? April?
Yes, ma'am. It's effective as of April 13th, 2020. And it's dated April 24th, 2020.
Okay. And what did that determine in relation to Robert L. Bailiffs Producer LLC's ownership in the drilling unit?
Sure. So they own a 16.25% working interest in a tract 3, which is an 80-acre tract. And so amounting as far as the entire unit for the subject lands here of 2635, it's roughly a 1% working interest in this drilling unit.
Okay. That makes perfect sense. Thank you very much. Turning now to, if I may, Exhibits G. Exhibit G, Exhibit H, Exhibit I, and Exhibit K. Do you recognize those 4 exhibits?
I do.
Okay. And are they official business records of XCL?
Yes, they are.
Okay. And were they prepared in the ordinary course of business?
Yes, they were.
Okay. What do these exhibits, Exhibit G identified as the JOA, Exhibits H and I identified as AFEs, and Exhibit K identified as well proposal letter, what do those 4 exhibits collectively demonstrate? What do they constitute? What do you think of those as, or?
So Exhibit G, like you mentioned, it's the JOA. So we provide those with the well packets. Exhibit H. Oh, I'm sorry.
Sorry, let me cut you off. So Exhibit G, H, I, and K, the JOA, the 2 AFEs, and the well proposal letter. That's a typical well proposal packet that XCL would send out to unleased or uncommitted owners. Is that right?
That's correct.
Okay. And go through, briefly, if you will, did you send a well proposal packet like this to all of the unleased or uncommitted owners in this DSU?
Yes, we did. We actually sent all of these packets out on about March 10th of 2020.
Okay. And do you know if, let's turn then to Exhibit M. Do you recognize this exhibit?
I do.
And was it prepared by my office under your direction or supervision?
Yes, it was.
Okay. And please tell the board what this exhibit is and what it demonstrates.
So what this is, it's a copy of all the returns for the proof of service that the agency action requests. So proof that we sent on and that they were received.
Okay. And to whom did you mail a copy of the request for agency action?
We mailed a copy to every interested party, which means every individual, every entity that had a record interests in the subject wells, as determined by the title opinion, the division or title opinion.
Okay. And did you mail a copy to Bailiffs, as you see on this bottom page? Let me exit out of that. You mailed a copy to Bailiffs at their last known address of record. Do you know if Bailiffs received this?
Yes, and yes.
Okay.
And received.
Perfect. In addition to mailing request, did you notify the unleased, or excuse me, the unlocatable estate owners in any other way?
Yes, we did.
Okay. And how did you accomplish that notification?
So, pursuant to the order, as the board of this cause, we caused to be published the notice of opportunity to lease or participate in the oil and gas wells for the notice of request for agency action. And so this is published in the Salt Lake Tribune, the Vernal Express, the Uinta Standard, each for 2 consecutive weeks.
Okay. And the notice of opportunity to lease or participate, what does that state, or what does it give notice of to parties who read it?
So what it's intended to do is to provide notice to any unlocatable working interest owners, all other persons, claiming any type of interest in the subject wells of this request for agency action, and allow them to participate in any of the subject wells.
Okay. And in this cause that we're here today, there aren't any unlocatable working interest owners. The only unlocatable interests are potential heirs or devisees of the named estates. Is that correct?
That is correct.
Okay. And to reiterate, the only uncommitted working interest owner is Robert L. Bailiffs Producer LLC. Is that correct?
That is correct.
Okay. Let's turn now to Exhibit L, which was submitted by Petitioner last week. Do you recognize this exhibit?
Yes.
Okay. And was this exhibit prepared by my office under your direction and supervision?
Yes.
Okay. And please tell the board what this exhibit is and what it demonstrates.
So this is a copy of the affidavit of publications prepared by the newspapers that we referenced earlier, verifying that if each published notice of the offer to lease or participate in the oil and gas wells and the supplemental request for agency action for those 2 consecutive weeks.
Okay, so this just proves that you published notice.
That's correct.
Okay. Has there been any leasing or agreements to participate with anyone since the filing of the request for agency action? And we'll get into this in more detail later, but has there been any leasing or agreements to participate?
There's been no leasing. There has been an agreement done between then and now with Oventive, RMI and Oventive Production. We have a JOA that we've both mutually agreed upon and executed.
Okay, so you negotiated a JOA during this process with Oventive and entered into that?
Yes, that's correct.
Okay, did Oventive, well, let me get back to that later. Now I'd like to turn you briefly, if I could, to Exhibit J. Exhibit J is titled Average Weighted Fee Royalty Calculation. Do you recognize this exhibit?
I'm sorry, I think you might have broke up.
Oh, sorry. Do you recognize this exhibit?
I do.
And was this prepared by my office with your input and review?
Yes, it was.
Okay. And please tell the board what this exhibit is and what it demonstrates.
So like you mentioned, and kind of what's in the name of it's the average weighted fee royalty calculation. And so what it encompasses is all of the leases with their net acres, and then what the lease royalty is, which is what they released at. And so when we go to the next column, we then take what the leased net acres are, and we divide it by, in this case, it's 1,200 or 1,200 acres, and I'll explain why there's 80 acres less here in a second. We then take the, that gives you the participation factor. We take that participation factor and we multiply it by what the lease royalty is, which comes up with the weighted royalty. And then at that point, we then add all those up to give us the average weighted royalty, which on this is 18.69%.
Okay.
And the reason why it ends up coming about 80 acres short is we've intentionally omitted the mineral interest by the Utah School and Institution Trust lands, as that does not go into the calculations on the average weighted rules per the Utah codes.
Okay. Okay. So we have a 1,280 acre DSU, but only 1,200 of those acres are used for the calculation of the acreage weighted royalty per statute. Is that correct?
That is correct.
Okay. And the acreage weighted royalty, again, you said for this cause that will be applied to any of the owners of, heirs or devisees of the estates who are force pooled at this hearing. What is that acreage weighted royalty that they will be assigned?
Sure, it's 18.696238.
Okay, so we could round to 18.7.
Yes.
Okay. Thank you for that. Now, finally, I'd like to address the JOA with you if I could. So let me pull that up. Do you recognize this exhibit?
I do.
And is this JOA, was it prepared by your office, and is it a business record of XCL?
Yes.
Okay, and was it prepared in the ordinary course of business?
It was, yes.
Okay. What form do you use for this model form JOA in the drilling unit issue?
We use the AAPL form 610, the 1989 model form operating agreement.
Okay, and the use of this form is fairly standard and practiced in the Uinta Basin?
Absolutely, yes.
Okay. In your opinion, are the terms of the JOA reasonable and customary in the basin?
Yes.
Okay. Are there any modifications from this standard form that you guys have included that are relevant to this hearing today?
Yes.
Okay. Can you give me an example of that?
Sure. So in this well, or JOA, we have the elected 100 or 400 risk assessment penalty. So what that is, that's 100% penalty applicable to the surface equipment beyond the wellhead, which is your tangibles. And then we have the 400% penalty applicable to all the drilling and completion costs, which is your intangibles.
Okay. And those are blanks that are left open in the JOA, and you guys have modified those to include 100 and 400%.
That's correct.
Okay. And what risk assessment penalty are you seeking for the board hearing examiner to impose on bailiffs in this unit?
Sure. It's a 100% for your tangibles and 300% for the intangibles.
Okay. Or I guess to dovetail with the statute, the surface costs and kind of below surface costs, if you will.
Yes.
Okay. In your opinion, are these modifications, the 100, 400, and others that you made in there, reasonable and necessary and customary in the basin?
Yes.
Okay. Has XCL entered into a JOA like this, or would XCL enter into a JOA like this?
Yes.
Okay. Exhibit C to the JOA Please tell us what this exhibit is.
So this is the form for the accounting procedures to be applied in conjunction with the operating of the subject wells, so our COPUS.
Okay, so this helps you figure out how to deal with money issues related to operations that are ongoing.
That's correct.
Okay, and the use of a COPUS is fairly standard practice in the basin as well?
Yes, that's correct.
Okay, now if I can have you look at paragraph 3. So let's just do this. Paragraph 3 here, titled Advances and Payments by Parties. Can you tell Mr. Rogers what this provision does relevant to this hearing?
Yeah, so this provides for the assessment of interest on the late payments for well costs.
Okay, and that's included in paragraph B here. How is interest rate determined under this JOA?
So the interest rate assessed for the late payments of well costs is based on the applicable prime rate, which is published by the Wall Street Journal, plus the 3% per annum. If the Wall Street Journal ceases publishing interest rates, then it's based on the prime rate published by the Federal Reserve plus the 3%.
Okay. Now, section 3 of the COPUS, I'm going to turn you to one last provision. In the section titled Overhead, can you tell Mr. Rogers what this provision generally provides?
So what this does is it deals with the overhead expenses and applicable fixed rates.
Okay, so this lays out what kind of overhead charges that an operator can pass on to all their non-operating participants in their wells that they operate.
That's correct.
Okay. In your assessment, the terms and conditions of the JOA, including the COPUS and the overhead expenses here identified, those are standard and reasonable in the basin, in your opinion?
Yes.
Okay. Now, I ask you kind of an obvious question. Were you asked by any of the interest owners in the unit to modify the terms of the JOA that we're discussing here today?
Yes. And, stated earlier, when we talked about getting another agreement done, I guess what I probably should have pointed out was the question was between, when we filed until now, have we reached an agreement? And we did on that JOA, but previous to that, after we sent the well packet out that included the JOA, we shortly began negotiating a JOA with Oventive during that time frame.
Okay, so when Oventive was not, when they received their well proposal packet, Oventive responded and shortly began negotiations on provisions of the JOA with you, it sounds like. Is that right?
Yes, that's correct. Back in March, I believe.
Okay. And you and Oventive eventually agreed to some revised terms in the JOA, and Oventive has signed a JOA. Is that also fair to say?
That is correct.
Okay. Do you mind sharing with us when that was signed, or is that?
Yeah, that's fine. We signed the JOA they signed the JOA on June 9th of 2020.
Okay, so it took several months to negotiate the changes.
That's correct.
Okay. XCL filed its current request for agency action on May 10th. It sent its well proposal letters on or about March 10th. About 2 months later, filed its request for agency action. If Oventive had not made an election by then, they hadn't signed a JOA by May 10th, why were they not included in the request for agency action as a party to be force pooled?
We didn't add them we did not add them, sorry. We were good faith negotiations. We felt like we were going to get there because they were making requests that were reasonable.
Okay. They'd already reached out and tried to negotiate their participation in the well.
Yes.
Okay. From a practical perspective, does XCL use forced pooling as a first course of action or as a last course of action?
I mean, as a absolutely last course. I mean, we seek to have good relations with everybody. So,
As much as you like spending time with me as well, I'm assuming you'd rather save the legal costs than go through a forced pooling if a business arrangement is capable of being reached.
absolutely.
Okay.
Sorry, man.
That's okay. And it sounds like Robert L. Bailiffs, Producer LLC, asked you to make some modifications to the JOA as well. Is that fair?
Yes.
Okay. When did roughly did Bailiffs receive the well proposal packet?
March 13th of 2020.
Okay. And they received the request for agency action probably around May 13th of 2020. Is that correct?
That's correct.
When did Bailiffs first send you its suggested JOA revisions?
June 5th, 2020, we received an email with their first revisions.
So Friday before the deadline to file a comment letter.
That's correct.
Okay. So in other words, Bailiffs waited nearly 3 months after receiving the well proposal packet to send you their first JOA revisions.
That's correct.
Okay. And nearly a month after receiving the notice that they were going to be force pooled at this hearing.
That's correct.
Okay. Without getting into too much detail, I want to help, despite our position that the requests made by Bailiffs are inappropriate and should not be entertained at this hearing, in order to address some of the division's underlying concerns. Without getting into too much detail, did you, XCL, evaluate these incredibly untimely JOA revisions requested by Bailiffs?
Yes, absolutely. We looked at them. Like you pointed out earlier, if there was any reason to save ourselves and our other participating owners money in the well, as far as because those costs, then get passed to them, we're absolutely going to do that. We looked at them and we quickly rejected those revisions, both because they were for one, untimely, and I think probably most importantly, they were unreasonable and non-economic for us.
Okay. Well, give me a couple real quick. Again, no reason to get into too much detail, but why did XCL determine that these revisions were unreasonable or non-economic?
Yeah, I mean they were clearly beneficial to Bailiffs and economically harmful to XCL and the other participating parties for this unit. And
there are other, aside from Ovintiv, there are other participating working interest owners in this unit. Is that correct?
Yeah, that's correct. We've entered into unit-wide JOAs with similar working interests and larger working interest owners and smaller on terms that are very similar to the terms of the JOA that we seek to impose at the hearing or today.
Okay. And has Bailiffs ever entered into a unit-wide JOA with you?
Yeah, actually they have. They entered into a JOA on December 2019. I believe it was actually on the 17th, December 17th. And it's identical terms that's included in that we seek to impose for this hearing. Okay,
so let me clarify that a little bit for the people listening. So the board, so Bailiffs in December of 2019 agreed to a unit-wide JOA for operation that contains essentially virtually identical terms to this JOA provision. 3 months later, when sent an additional well proposal packet with the same JOA, at the 11th hour has submitted necessary revisions to that JOA to protect themselves. Is that a fair restatement?
Yes, that's correct.
Okay. So just to be clear, Bailiffs voluntarily agreed to this virtually identical JOA 4, 5, 6 months ago.
That's correct.
Okay. With that, I'm done with my examination of Mr. Annenson. I don't know, Mr. Rogers, if you'd like me to proceed with Mr. Sigler, or if you'd like to give Ms. Souza a chance to cross-examine before we move on.
What would the division prefer this time?
I think it'd probably be easiest to just ask our questions now for Mr. Annenson so that he doesn't need to come back later.
Okay, let's see.
I'm not, just for the record, I'm not going, I'll be here during Josh's as well. So. We're all about geology talk. I mean, obviously ask whenever, but I'll be here if you wanted to wait. It doesn't matter to me.
I'll ask him now since they're fresh in my mind.
Okay, perfect.
So, Mr. Annenson, Mr. Mayo asked what about the terms that Bailiffs had proposed were unreasonable, and you said that they were clearly beneficial to Bailiffs, but they pose severe economic harm to XCL and to the other parties. And so I just wanted to ask you to please clarify what that economic harm is that would occur to XCL.
Mitch, is it okay if I answer that?
Yes,
Okay.
of course it's okay.
Okay, I just want to make sure to know if any of it was.
Yeah, I mean, I would like to renew my objection to Bailiffs asking those questions, but obviously,
Yeah, of course.
This is the division, you're fine.
Yeah, so one of the provisions requested for change was a period of time between when we drill the well.
You know, Kevin, actually, the probably the best provision to use as an example is the marketing costs provision, because
Sure.
that applies really directly economically to other interest owners as well.
Yeah, sure. So the marketing provision was they wanted to be treated the same as royalty owners, so your mineral interest owners, and not bear the cost that the working interest owners bear.
Did Bailiffs, when he sent you guys your his initial or their initial response and these requests for modifications, did Bailiffs include in that initial request the edits that he submitted with the letter that was submitted to the board? Those edits occur in Article 6A of the JOA?
Yeah. So we did. We received that in that June 5th email, I believe, is when we received those edits. I believe you're referring to in the Robert L. Bailiffs letter to the commission. Yes, we received those on June 5th, I believe, was the date.
Yeah, and Haley, maybe I can clarify. I could be mistaken, but I believe there were more revisions requested on June 5th than were included in the revisions sent to the division.
Sure. Can XCL speak to the specifically just to the revisions that were sent to the division in this letter from this comment letter? So there may have been other requests that Bailiffs had made to XCL that XCL determined were caused economic harm to XCL and to the other parties, but it appears as if those requests haven't been made in their comment letter to the board. And so if we could just tailor your response to the specific maybe not minor, the specific changes that are in the JOA that was sent to the board, that would be helpful for the division to understand what economic harm that poses to XCL and to the other parties if those changes were made.
Yeah, sure. So if you want to, sorry, Josh has it on his screen here. So under Article 6,
I can try and pull it up on the screen for everyone if that's helpful. I don't know if I can, but give me 1 second here.
Do you have are you going to bring up the Bailiffs letter?
I was, but let me see if I can find it here.
I can talk through it pretty well.
Okay. Yeah. Why don't you start and I'll.
Sure. Okay. So Article 6, B, which is your subsequent operations. At the end there, they added any substantive changes to the proposed operations will require a new proposal to the parties. Substantive changes include a change in location, objective zone, or suspension of operations. So for one, a change in location and a change in objective zone are already covered under this provision. That's what a proposal is. So that is just reiterating what's already there. So if those two items were to change, they would already receive a new proposal. What stuck out there was the suspension of operations. We do not feel like if there's a suspension in operations being between drilling and completions, that a new what they put here, a new proposal, I guess we'll call it, should go out. The reason why is there are different items or different things that can occur between drilling and completing of a well. What we've seen more recently was the pandemic. When we started operations on this well back in February, I believe, is when we spud it. Oil prices were, I can't remember, mid-50s. And when the elections went out, I believe they were within that same oil price of 50s or 40s. So, we've got rig contracts, different things like that go on. So, we continue to operate, and we obviously don't control crude prices. So, for someone to get a additional election because something may have changed between drilling and completions is unfair to not only us, but our other participating parties that would then have to bear that cost. Because let's say, for instance, crude prices drop and they never come back up, but one party gets out of that risk. It's just another way for someone to push the risk back and push the time back on their election so that they have the least amount of risk whenever it's actually time to complete the wells.
Bailey, do you mind if I hop in with an operational comment here before my section on that note?
Sure.
Kevin spoke to one specific circumstance, but maybe another circumstance to consider would be, say, any of these wells required a sidetrack, and we felt that we needed to suspend the operations in order to plan that wholly. Well, allowing operators or non-operational parties who are working interest parties here to be able to have that opportunity to hop out of the well because we need to suspend the operations, we believe is not, it would obviously be negatively, it would negatively economically impact ourselves and the other working interest parties. And that's part of the inherent risk involved in drilling oil and gas wells. And so, giving one working interest party the ability to hop out of a well while all the others are left footing the bill is historically not been anything that operationally has been allowed. And we do not feel it to be fair for one working interest party or any working interest party, nor would we seek to do the same in other operators' JOAs.
And if I could play Mitch for a second to you, is it accurate that if we are pad drilling, we are going to be drilling wells back to back to back in a unit and then later coming back?
Absolutely.
There, so there is a time between when we're suspending completions.
That is absolutely true, Kevin. So if you look at the two wells at interest here, the 64H and the 104H, we temporarily suspended operations on both wells to move from one well to the other well and save ourselves money in the scope of things. But there would certainly be an opportunity where somebody could say, well, you've suspended operations at the intermediate hole section. We would like to be able to have that opportunity to now think about getting out of this well. And again, that's not what we believe are the rules of the road of the oil and gas industry.
Does XCL have a timeline on when it expects to complete these two wells?
I would say high level. We're closely following, crude pricing. as we think it's prudent that we drill and complete at a level of economics with a higher WTI. Also, we would like to finish drilling the remaining wells in this unit. As kind of like Josh was saying, you want to go out there and complete all at the same time, as that's the most economic way to do it and the best way to preserve the reservoir and the economics of the unit.
Is there currently plans to go out and finish those other 5, or I'm sorry, not to finish, but to drill those other 5 wells?
Yes, currently there is, yes.
And what's the time frame on that?
I don't know that I have that answer.
I think that's something, as Kevin said, there are certainly plans to go do it. We are currently, we believe it's prudent to monitor the price of commodities right now. And so we'll be monitoring that closely. And obviously the earliest opportunity where we feel it's economic, we will be continuing operations on these wells to drill them and complete them.
And as a note, we did receive, whether it was verbal or through an email from our other parties, that they have agreed with, every step of the way that we've chose thus far.
The division recognizes that there could be economic harm caused by allowing parties to jump out, like you guys said, if they're having to receive another proposal. But the division also recognizes that there's economic harm in the uncertainty of throwing a bunch of money down and never knowing if and when you're ever going to recoup your investment. Because as you're saying, you don't know when you're going to complete the 2 that exist, but you do know that you will complete them after you drill the other 5, but you don't know when the other 5 are going to be drilled. So can you speak to the economic harm in not allowing, or I guess what I'm trying to ask is, does XCL recognize that an economic harm does result from the uncertainty of never having a timeline for when a well will be completed?
Well, and Haley, maybe I can jump in and say something real quick, if that's okay. I guess part of the answer is this happens all the time in oil wells, oil development, all over. This is just a function of reacting to what's happening in the environment, and an operator is tasked with being prudent. They have to make sure they're producing only when it makes sense. What I will point out to the division is Bailiffs doesn't have a right, an absolute right to participate on terms that are fair and reasonable to them. They have the right to be given an opportunity to elect to participate. They have every right to negotiate a JOA and sign it and not spend a single penny. They can elect to go non-consent. And so there isn't any economic harm to them unless they make a certain series of choices. And if they choose to participate, it's because they see a financial benefit to that, or a potential financial benefit to that. And if they make that choice and then an unknown pandemic comes and closes the economy, they are stuck with that choice, just like XCL, just like Oventive, just like Rig 2 and any other partners in this well would be. And sorry to cut you off there.
No worries. So changing direction, we talked about that Bailiffs had executed an identical JOA unit wide, but I was just confused. Is that was that for this unit, or was it for a different unit, or?
It's for a different unit.
Okay.
It's a unit that's about 2 or 3 miles there to the east of this unit, within the same field, more or less.
Did
Haley,
Bailiffs?
to the extent you care, it's 30 and 31 in 2 south, 1 west.
Okay, thank you.
Maybe on our end. Give us 1 second, guys. It looks like we can't hear anybody.
Did you get it back?
You don't hear us, Mitch? Oh, no, we can't hear anybody.
I can hear you guys, but.
Okay.
No, you're back.
We're back. Sorry.
Okay.
Did you hear my answer?
Yes.
On the third? Okay.
Yes. Did Bailiffs execute AFEs for either of these two wells?
They did not.
Okay. Mr. Rogers, would you mind if if I take a quick break and confer with my client via telephone?
Sorry, I was muted. No problem, that'll be fine.
Thank you.
John, just so you're in the loop, we're going to confer with our counsel as well at this time.
Okay, is everyone back or are we still waiting? Okay. Mitch, you there?
I am back, and it looks like both of my witnesses are back as well.
That is correct.
Okay. And Michelle, everyone okay here? Well, let's proceed then.
Thanks, John, for the opportunity to confer with my client. We don't have any additional questions for Mr. Anderson at this time.
Okay, Mitch, back to you.
Okay, if I can quickly do a little redirect with Mr. Anderson, and then we'll pass him along. Kevin, remind the board or the hearing examiner, if you would, of the timing of this. You guys drilled the wells in early March, around the time you sent the well proposal letters. Do you remember roughly what oil prices were at that time? Ballpark?
Yeah, approximately around $50.
Okay. And so you drilled them and proposed them at a time that was prudent to drill.
That's correct.
Okay. And you had other operators agree to participate in those wells during that time period by signing a JOA and making an election on the AFE?
That's correct.
Okay. And when you saw oil prices start to drop precipitously, you held off on producing. You even pulled back drilling additional wells, both of which seem like really prudent decisions.
That's correct. When we sent the elections out, it was for 7 wells, and we rescinded the letters or for the operations for the remaining 5.
Okay. And one last question: did Bailiffs ever, and maybe you don't know this, but did they ever say to you or intimate that they were interested in participating and paying their proportionate share of drilling costs?
I'm sorry, our screen blacked out for a second. Can you ask me that again?
Yeah. And maybe you don't know this, but did Bailiffs ever tell you whether it intended to participate and pay their proportionate share of drilling costs?
No.
Okay. So if you had to guess, would you say that Bailiffs would participate or elect not to participate in this well?
Non-consent, not to participate.
Okay. So Bailiffs, you don't get the impression that Bailiffs is interested in putting their money into drilling these 2 wells, regardless of what the JOA says.
Correct.
Okay. So it's kind of a false question in some ways, whether Bailiffs' money is going to be inappropriately tied up, because Bailiffs, at least as of yet, has not offered or suggested that they would be willing to put up money for drilling costs.
That's correct.
Okay. With that, I'm done with Mr. Anderson and ready to move on unless there's any further questions. Seeing none. Mr. Sigler, I'm going to turn it to you now.
Yes, sir.
Could you please state your full name, spell your last name, and your business address for the record?
Absolutely. My name is Josh Sigler, S-I-G-L-E-R. I'm the Vice President of Geology here at XCL Resources, and our business address is 3217 Montrose Boulevard, Suite 200, Houston, Texas, 77006.
Okay. And you just said you are the Vice President of Geology for XCL, and I'm assuming that covers the unit that we're here discussing today?
Absolutely. Covers the generally all lands that we own or are operators for in the state of Utah, and serve a range of functions from advising on geologic matters to oil well drilling, completion to some degree, and general operations.
Okay. And the board and division have received your resume. Just to refresh the hearing examiner, excuse me, Mr. Sigler has been qualified as an expert and will be testifying as an expert in geology and general development operations today. Mr. Sigler, I'd like to turn you first to Exhibit 32 and Exhibit 34. Excuse me, Exhibit D and Exhibit E, which are at pages 32 and 34. Do you recognize these 2 exhibits?
Yes, sir.
And were they prepared?
They were. Sorry. No, yes. Go ahead.
They were prepared by you and your office?
Yeah, under our supervision, that's correct. They were prepared for us.
Okay. And tell the hearing examiner what these exhibits demonstrate, what
Yes,
they are, what they show.
Yep, they're well location plats, and so in this specific instance, they show the locations of the Butcher Butte 3564H-22 and the Butcher Butte 35-104H-22 wellbores. They show the surface location, and then the intended path of the wellbore to be drilled, including the beginning of the build section and the target bottom hole section. Both of those being, to clarify the well locations plats just a little bit, the surface holes are in Township 3 South, Range 2 West, and then both the build and start of the build and the bottom hole then are in Township 2 South, Range 2 West. For a little bit of clarification there, Mitch.
Okay, so even though it says 3 South, 2 West at the top, that's just that identifies the surface hole location, which is off lease in this drilling unit.
Absolutely.
Okay, and so this is the surface location for the 64H well, and it looks like it's going to go this way somewhat. And these are, not necessarily actual depictions, but fairly close to accurate. And then it's going to proceed up, and this will be the target bottom hole. Is that correct?
Absolutely. Yes, correct. From the surface hole, we kick out to the east and then build our curve to drill the lateral section northward.
Okay. And then same for Exhibit E. This is the 104H, and it looks like it's got a similar surface location. This is from the same drilling pad. Is that correct?
Yes. Yep, it's very similar figure, just a slightly longer kick out to the east there. And obviously, as mentioned, we pad drill to try to make sure that we are minimizing cost for ourselves and all working interest partners.
Okay, that's a good segue. Let me switch over to discussion of costs. Exhibits H and Exhibit I. Do you recognize these exhibits?
Yes, let me flip them in my document real quick just to, can you give me a page number there, Mitch?
I've got 87 and 88, if you're curious.
I dropped out again. It's 87.
That's right.
Thank you. Yes, I recognize those documents. Those are our XCL resources authorization for expenditure, or AFE document that details the costs intended to be outlined with the drilling and completion of this well, these wells.
And the Exhibit H?
Volume issue here.
Oh, shoot.
I'm back. We're back.
You all right?
I'm all right. I'm not sure the television that we're watching you is all right, but we're working our way through it.
That's okay. You don't need to see me to do this part, I don't think. So
I need to hear you, though.
You do. Well, let's see. So can you hear me okay and we can proceed, or do you need a minute?
Absolutely. No, I can hear you okay and we can proceed. Just bear with us if I mention for you to hold up again for a minute where I see your lips moving but don't hear anything coming out.
Okay. So this Exhibit H, it looks like applies to the 64H well.
That's correct. Exhibit H applies to the 64H well, and Exhibit I applies to the 104H well.
Okay, and these, as you said, identify estimated drilling and completion costs for people so that they can evaluate whether they want to participate in the 64H or the 104H wells. Is that correct?
Sorry, Mitch. It's happened once again here. I didn't hear the end of your question, and let me see if I can get this volume back and going. For whatever reason, it has stopped.
No problem. Take your time.
I don't know either. Yeah, that's a good idea. Oh, there it goes. All right, Mitch. I think I'm back now. Many apologies for this.
That's okay. How does that work? Can you hear me at all?
I can hear you now.
Okay. So I just asked, these authorities for expenditure, AFEs. Exhibit H details the estimated cost of drilling and completion of the 64H well. Exhibit I demonstrates the expected or anticipated drilling and completion costs for the 104H well. Is that correct?
That is correct, sir.
Okay. And what are the, so that people don't have to try and squint and read, can you tell us what the estimated costs are for each of the wells?
Absolutely. For the 64H, it's $544,467 total cost. And for the 104H, it's $10,553,317.
Okay, so about 10 and some change for each well.
Let's call it $10.5 million for each well.
Okay, and what was Robert Bayless's percentage, or they have a 1% roughly ownership interest in the drilling unit. Do you know what their proportional share of costs would be for each of the wells and collectively?
Yes, sir. Those well costs are roughly $107,000 for each well. I can give you specific figures if you'd like it out to the cent.
That's good enough. Round numbers are good. And the total cost then would be about $215,000 if they wanted to participate in both wells.
Correct, sir.
Okay. And just to point out, the other 99% of those drilling costs, roughly by my calculation, $21 million minus 200,000. So $20,800,000 would have to be paid by XCL and the other committed working interest parties in the drilling of this well. Is that correct?
That is correct, sir.
Okay. And everyone else has made their election. So everyone else either has elected to go non-consent or has put their capital to work on these two wells.
That is correct.
Okay. Briefly, I wasn't planning on this, but one of the things I'd like to address in Bailiff's comment letter is this suggestion, if you will, and let me pull up their letter so I can read it. Their suggestion that XCL could in some way, or might in some way, propose, I'm going to paraphrase, 10 wells at, $10 million apiece, all to be drilled at the same time, for a total of $100 million in a drilling unit. That they would drill those 10 wells and then choose to leave them uncompleted for some unknown period of time in an attempt to take the 1% owners' interests. Can you state definitively, or explain your answer if you can't say definitively, would XCL ever put $99 million of drilling capital in the ground, not expecting a rate of return anytime soon, simply to get a 1% interest owner's interest from them?
No, sir.
Okay.
I mean, I think that we could try to kind of make up some mathematical situations to try to describe that situation. But I think the simplest statement is that is not a good use of our working capital. We are a company that has to work with a budget, and we are not in the business of trying to take a significant portion of our budget and attempt to tie it up in an attempt to gain non-consent interests. Our business is drilling oil and gas wells such that we can drill them, complete them, produce them, and make money off of that produced volume.
And I'm assuming, correct me if I'm wrong, in that scenario that your other committed working interest partners would be up in arms if you decided to tie their capital up for an unknown and undisclosed and unending amount of time just to secure an additional 1% interest.
Maybe to phrase it slightly differently, as I do not know what other working interest parties think. If we were a working interest partner with someone else who did that, we would very much be up in arms in that situation.
Okay. Thank you for that. Let me go back to the costs in these wells. The $214,000 roughly in costs that represent Bailiffs' proportional share of the drilling costs in these two wells. Has XCL paid those costs on behalf of Bailiffs?
Yes, so far we've paid the proportionate costs on the drilling side of things. There's certainly still a portion of the completion costs that have not been paid yet, but the proportionate share that relates to the drilling of the wells, yes, we have.
But no one has paid the completion costs.
That's correct.
None of the partners, because it hasn't been completed yet.
Correct.
Okay.
Which I think to maybe use that to speak to part of your own line of questioning, we do not like tying that cost up of our own working capital, leaving the dollars in the ground and not producing these oil and gas wells for any extended period of time. We are certainly monitoring the situation so that we can get these wells online and get a return on our investment as soon as possible.
Sure. And to be prudently operating on behalf of everyone else within the unit.
Absolutely. We can consider both our backers as well as the other working interest partners as investors in these oil and gas wells. And we want to give, and frankly, we are investors in these oil and gas wells, and we want the best return possible. And we are working to do everything possible for that purpose.
Okay. Thank you. In your expert opinion, were these costs that are delineated on the AFE, at least for the drilling side, but also for the completion side, are those fair, reasonable, and something that are necessarily incurred in this process?
Absolutely. These well costs are generated based on historical wells that have been drilled by XCL and their predecessors. And so these are very reasonable costs. Okay.
XCL's pretty new to the basin, relatively so, taking over for Axia 6 months ago. I'm assuming that you are in the process of, do you have any idea as to where these well costs sit, as to what you plan to get for well costs? I guess the question is, these are probably largely inherited, both contracts, et cetera. What is XCL's plan for drilling costs?
Yeah, Mitch, as mentioned, we plan to work toward the most economic wells possible. And so XCL's plans are to continue to try to drive these costs lower and lower, thus making the most economic wells possible. And so, these are our anticipated costs from the wells we've inherited. Our hope is that we can continue to drive these costs even lower, and be good stewards of our investors' money, as well as also then be able to try to be good stewards of the resource we have for U.S.M, SITLA, the state lands, everybody in Utah, private owners, for that matter. We intend to do the best thing by all our investors.
Okay. And you don't include on these AFEs plugging and abandoning costs. Is that typical for you?
Well, that is correct, sir. We do not include plugging and abandoning costs in these AFEs.
Okay. That's a separate cost that you will joint interest bill for later on?
Absolutely. At the appropriate time where we determine that these wells are no longer producing in economic quantities, we will then AFE similarly for these wells much later in the future.
And part of the reason you don't do that now is because those costs, even though they are absolutely necessary, and at one point everyone in this unit will have to pay to plug and abandon these wells, it's going to be a ways down the road, and XCL leaves it off because it's inappropriate or unfair to include those at this point and have people tie up capital. Is that part of the reason?
That is absolutely. We do not want to tie up our own capital for that purpose, nor would we expect our investors to tie up their capital without a full intent to utilize the capital.
Okay, so you wouldn't bill for it till you need it.
That's correct.
Okay, and can you estimate for this hearing what the plugging and abandoning costs of these wells would be?
Yeah, the plug and abandon cost for these wells would be roughly $100,000 per well, or $200,000 total.
Okay. In your opinion, talk about the risks, if you will, of drilling these two wells. Obviously, there's economic risks, and I think we've talked about that enough. But just drilling wise, what kind of risk can you help us understand?
Absolutely. The Uinta Basin is an area that's very fortunately bestowed with a large amount of hydrocarbons that happen to be highly overpressured. But that then means in our operations, we have to deal with a lot of pressure, and that leads to significant risk on both the drilling side and then eventually the completion side. Behind that, all these operations take extra care and precaution and certain measures, not only to make sure that we have economic wells, but also that we're conducting our operations safely and in a manner that's environmentally as rigorous and strenuous as possible. With that, anytime you're mitigating risks, there is a certain amount of cost that comes with mitigating those risks. But obviously, the economics of these wells are such that those costs are worth it. But there is significant risk involved that this is an unconventional or continuous resource, so it's much less of a dry hole risk, but much more of an operational risk that, as we're drilling 10,000 feet of lateral and getting to 20,000-ish feet measured depth, that things can go wrong along the way, and there is significant risk. And I think all oil and gas operators these days should be fairly familiar with the risk that comes with drilling horizontal wells.
Okay, so the risks maybe aren't necessarily in drilling a dry hole as they used to be or can be in some other basins. The risks are largely dealing with the unique geology in Utah, and also, kind of the inherent risks in every drilling operation. 3 or 4 months ago, you were here before Mr. Rogers again because a wellbore blew out along the way through really no fault of anyone. It just, those things happen. That's the kind of risk that's inherent in the drilling of these wells. Is that correct?
Yeah, one correction there, Mitch. I wouldn't say that the wellbore blew out. I would say that we had an issue with cementing that wellbore, and that led to some mechanical issues that we had to think very hard about.
Thank you. That's a very much more delicate way of saying the blunt thing I said.
Yeah, I do not.
That did not. Well, no, totally different.
Yep.
Okay, well, and to reiterate, Mr. Annenson stated that you guys are seeking today in this request a 100%, 300% tangible, intangible risk compensation award from the hearing examiner. Do you believe that the risk in these wells justifies that risk compensation award?
I do, sir.
Okay. With that, if there are no further questions or no cross-examination by the division, I'm done with Mr. Sigler.
Okay, thank you, Mitch. We'll turn the time for the presentation to the division.
The division has some questions for Mr. Sigler. Is that okay?
Of course.
Can we look at this authorization for expenditure before you take it down, Mitch?
Yeah, if you just want to tell me what to turn to, I'll do that, Haley.
We just need this page
Okay,
a little bit bigger, maybe. Not
which
bigger,
one
but
is it?
we can see more of it.
Mitch, I can't see the header. Just to make sure that we're on. You are on Exhibit I, correct?
I am on Exhibit H and I. I'm not sure which one I'm at yet, but I'm gonna.
It looks like the 104H, so Exhibit I. Fire away, Haley.
Where was I?
So these AFEs, they include both the drilling costs and the completion costs. Does XCL receive the portion for drilling costs, complete the drilling, and then when it comes time for the completion stage, then they obtain the funds for the completion stage? Or does XCL obtain the funds for the entire amount?
Haley, I would like to redirect that to Mr. Annenson, who's in charge of. So can you explain the joint interest billing process a little bit more?
I don't know if I can't tell if the question is, do we have a fund where all of our money comes from, or do we ask for drilling?
Yeah, so maybe the broader answer, Haley, we do not ask for all this money up front. We do not ask for anyone's $10 million, take it, put it in an account, and escrow it there. We bill along the way. If you want more details, I would refer you to Mr. Anderson.
So let me see if I can clarify from a lawyer standpoint. These are authorities for expenditure. So these say we authorize you to spend $10 million. It's not a bill. It's not an invoice. No one sends in a check in response. What happens then is once you've signed a JOA and authorized these expenditures, then the operator will invoice you as they've incurred costs. So because there are drilling costs incurred to date, anyone who is participating in the well has been invoiced, presumably, and paid those costs. But because completion hasn't occurred, no one has been invoiced for those costs yet. Is that fair, Josh, Kevin?
Yeah, that's correct. Yes.
And maybe to add one kind of anecdote for you as well, Mitch. There were multiple times in my career, both at ExxonMobil and Wild Horse Resources, it hasn't come up yet here at XCL Resources, where I've received, as a working interest partner, I've received an authorization for expenditure where we looked at the costs and the expected economics of the wells. And we decided that what the other operator was going to do was not economic, and we chose to non-consent because we did not feel either that their costs were appropriate or that the economics of the time were appropriate for drilling the well. That is certainly any working interest partner's right once they receive the authorization for expenditure to decline it.
Okay. Sorry,
That
Haley.
answered your question, Haley. Sorry, I didn't.
Yeah.
It does. I have another question, but it's more for curiosity.
Yeah.
Mr. Sigler, you said earlier that you guys don't include the P&A costs on this AFE because you wouldn't bill for P&A until you need it. But what you just told me was that you don't bill for completion until you need it. So why would you not include the P&A on the AFE?
It's probably a little. I knew what I was saying as I was getting there. Part of that's just the length of time that's in between there. In a typical procedure here for the drilling and then the completion, the obvious hope is to drill the wells and shortly thereafter that will then complete the wells. In a pad drilling scenario like this, I would say it's actually very rare that you finalize drilling a well and complete that individual well immediately after you've done so. You almost always wait until you have a package of wells, say in this case, we had planned 7, and you'd wait till those 7 wells are done, and then you would move to completion shortly thereafter, sometimes with a little pause there to make sure that we can get the best economic rate as well on our frac crews and things like that coming in. But we want to have that expenditure authorized so that in the moment the frac crew becomes available, we can pick them up instead of having to wait once say if we only AFE'd for the drilling portion, but then we have to wait to also then authorize the completion portion. We're then left waiting and potentially incurring more costs for not only ourselves, but all the investors, the other working interest partners. The plan for these wells and many other wells is that P&A liability is much, much further. We're talking 10, 20, if it's a great well, 30 years down the line. And so there's a much greater gap in time there. And so if you think about what asking an operator to think about this year's budget is one thing versus saying, hey, I want you to think about your budget in 10 years if you still operate or if you're still a working interest partner even on this asset. It's a much, much different game.
Okay, so Mr. Rogers, the division is completed asking questions of Mr. Sigler.
Okay, thank you. At this time, I'd like to confer with my counsel, so why don't we take a short break?
Okay.
Thank you, Mr. Rogers.
Mitch Mayo is back.
We're
John,
here as well.
this is Haley. Can I have a quick second longer?
Sure.
Thank you.
Give you the opportunity to present your case in chief. I'm not sure if I blew by that or not.
Not yet, and I was hoping to have that opportunity, but
Okay.
it will be brief.
Okay.
It will be
We'll
very brief.
begin with that.
On-
Haley, if you want me to switch to any exhibits, just let me know. I'll go mute now.
No, we won't need an exhibit. The division just wanted to clarify one. Actually, Mitch, could you leave that one up? I take it back. We do. I would like that. The division just wanted to clarify, and Dustin Doucette is on the line just in case I completely botched this. So the division just wanted to clarify that in the AFE there should be, and I'm sure that there probably is, if the font were larger I could see, that there would be some dry hole costs which would anticipate P&A in the unlikely event, particularly in the basin, that the well drilling does produce a dry hole, just so that all the parties know and understand, what those costs might look like. Mitch, you're talking, but we don't hear you.
He's muted.
Okay. So on to the divisions, just finishing up what the division has. The division just wants to recognize that
Haley, sorry, let me jump in. You asked that question. I was trying to show it and talk at the same time, so I'm going to leave myself on. But if you look here, I'll go to full view. It does identify plugging costs in the dry hole cost. It's just
Okay.
left. It's just left blank.
Okay.
So.
Oh, I see. Okay.
So there just isn't a cost allocated, but there is a line there for it.
This is Dustin. I'll just jump in real quick. I think the point was that the parties do need to know what those costs are up front in the unlikely event, so they can make a decision and evaluate that. Because if it is a dry hole, they will incur those costs immediately, not in the future.
That's a fair point.
Okay, so the division just wants to reiterate that we understand, based on XCL's explanation about the billing for these costs, we understand that the costs for completion aren't physically tied up in this situation, but the division does want to just point out that while those funds may not physically be tied up, they are tied up because they have to be allocated on the books. And so we just wanted to recognize that completion should occur as expeditiously as possible after drilling. And we understand that in these specific times, that is, there's so many variables that are preventing that from happening in this situation, but we would hope that in normal times that completion would occur as expeditiously after drilling as possible. And Mr. Rogers, the division supports the force pooling request for agency action insofar as it covers these 2 wells, and the division requests that the order clearly delineate that the other 5 wells are not included in this specific order. And I believe that that's what the request for agency action is stating, but the division just wants it on the record that that's our understanding and that's what the division supports.
That is true. There are only the 2 wells that are issued today.
Okay.
And that's everything the division has. Thank you, Mr. Rogers.
I had numerous questions written down before this, but I feel that the presentations were excellent, and those questions have been answered by what the division has asked and through your presentation, Mitch. So I will turn to you for closing.
Okay. Before I do that, I think I might have missed a step, or maybe now's the appropriate time. I'd like to move for admission of our exhibits.
Okay, we can do that now.
Exhibit A through M in this cause.
Okay, so accepted.
Okay. In some, XCL is here force pooling estates or unknown heirs or devisees of estates to the extent necessary, but that's not the real issue today. XCL seeks today and has shown today that it has provided Robert L. Bailiffs producer with an opportunity to participate. Robert L. Bailiffs producer has yet to make an election, and they have not, at least as far as XCL is concerned, has not once identified a desire or interest to participate in these wells. A lot of the concerns that have been discussed have been related to the tying up of capital. And what I'd like to make sure we are all clear on here at the close is that all of the parties who have consented or otherwise agreed to participate to pool their interest in these wells, not one of them has complained about having their capital tied up. It is Bailiffs who to date has manifested no intention to put any capital into these wells whatsoever, who is bemoaning having their capital tied up. The other thing I'd like to make clear to everyone here is that Bailiffs had every opportunity to negotiate a JOA with XCL. Ovintiv did that. They did it responsibly. They did it right out of the gate. And XCL and Ovintiv worked out a business solution that avoided the necessity of this hearing for Ovintiv. Had Bailiffs reached out and proposed a JOA revision immediately or sometime earlier, is it possible that a business solution might have been reached? Absolutely. I don't believe the provisions they've requested would have been any more reasonable 3 months ago than they are today, but the conversation would have started. And I think what the rule requires is good faith negotiations, regarding participation within 30 days of receiving an election. The election well proposal packet was sent, as was testified today, in early March, March 10th, and was received on or about March 13th. That means by about mid-April, Bailiffs was under an obligation statutorily to, and XCL was as well, to engage in good faith negotiations to secure their participation. Unfortunately, the JOA revisions were not received until less than 2 weeks ago. At that point, there wasn't much room, and to be honest, XCL had already invested significant amount of legal fees in pursuing the compulsory pooling, which legal fees will be passed on to all the other parties in the well. I'd like to remind you, Mr. Rogers, that all statutory and regulatory requirements have been met in this instance, that the relief requested in the request for agency action is reasonable and in keeping with standard practice in the basin, that the imposition of the JOA in this cause is fair and reasonable, especially with Bailiffs, given that they have executed a similar unit-wide JOA with XCL only months ago. And finally, to the extent that Bailiffs has any concerns with the JOA, I'd like to remind you, Mr. Rogers, that the Bailiffs will have their opportunity to, again, negotiate terms of a JOA and even seek relief from the board if they believe that JOA provisions are unreasonable under the new compulsory pooling rules when XCL does decide to drill any future wells in this drilling unit. And so because of that, I would ask the board to approve the request for agency action as presented, and I will rest. Thank you.
Mitch, just one question I had and I failed to ask was,
Sure.
would you allow bailiffs to sign on now, or is it past that window if they chose to, given the standard JOA?
Well, I mean, I got to be honest. I'm imagining that's more of a question for the XCL guys. Would I allow it? I think that's.
Yeah, I guess that's for your clients.
But I do think. I think there's competing concerns. One is they've already incurred legal costs that they have to pass on to the other working interest owners, and that's somewhat unfair at this stage in the game. From an XCL perspective, I know they would prefer to have a unit-wide JOA in place and have, contractual rules that apply so everyone knows what's going on for future operations. The other thing is XCL has requested only a 3% or a 300% risk compensation award here. If Bailiffs were to sign the JOA and elect to go non-consent, they would have a contractually imposed 400% non-consent. And so, I'm not sure whether XCL would agree to that today, but the one thing that I know is shortly before the hearing, a couple days before, and Mr. Ananson can nod his head or hop in if he disagrees, he is still under oath. But XCL's last conversation with Bailiffs was, of course, you're welcome to sign the JOA that we presented if you'd like to. And so, I do believe that XCL would consider it, but I would obviously leave it to them to decide whether at this point in the game they would accept it. Kevin, do you have any thoughts to add?
No, I agree with everything you said. At this point, we've incurred legal fees. I think at this point, it would only be fair that those legal fees, be paid a big portion, or they pay, a portion of that as they've had 3 months to work on a JOA. They were even told before we filed for the compulsory, for the hearing, for the pooling, requested that, hey, if you guys, would sign a JOA so we don't have to go through this. I would have concerns that they would actually even, sign the JOA at this point. So it's something we would consider, but, my gut is A, they wouldn't, and B, I think that train's kind of already left the station.
Okay. Thank you.
Yeah, thank you, John. Great question.
Okay. Mitch, anything else?
That's it, unless there's anything further.
Okay. Haley, do you have any closing?
Oh, actually, John, I apologize. There was, there's still a pending motion to strike the requests in Bailiffs' letter, understanding now that the division has done a full-throated kind of delve into that. I do think it's important from a strictly legal standpoint, especially as we go into implementing these new force pooling rulings, that we have really clear rules as to what kind of participation is allowed and how that is allowed. So I do think the motion to strike is well taken, but I just wanted to remind you that you and Gordon wanted to wait on that decision until
Yeah,
later.
I'm gonna speak with Gordon in a moment here.
Okay.
So. Haley, did you have anything else in closing?
No, we didn't.
Okay. I'm gonna take a few minutes here and meet with my counsel. So let's take a break and I'll be back as soon as possible.
Thank you.
XCL
I'm
Resources.
ready.
Okay, I don't see him. Oh, there he is.
The division's here too.
Okay. I will grant the motion to strike the letter from Bailiffs Company. From my counsel, we discussed that it wasn't filed as an objection, it wasn't filed as a motion, and it wasn't filed by an attorney. But we'll treat it simply as a comment letter. I think, in all fairness to XCL and other working interest owners, I think we need to recognize the risks they have taken. Bailiffs has had the opportunity to sign on as a working interest owner under the conditions that other parties have agreed to. And so I'm inclined to recommend that this request for agency action be granted as written, and recommend that we go with the 300% penalty as requested, and we'll grant this motion. So Mitch, could you draft that order?
Yes, I'm happy to. I appreciate that. Just to clarify, and I'm guessing since Gordon's on here, I can see him now. you said you're granting the motion to strike the letter. The motion was tailored just striking those requests, and the rest of the letter is to be considered as a public comment. I don't want to take away their right to public comment. They're entitled at any time to submit a comment letter. I just want to make sure that any specific requests are.
Okay, so the motion
stricken.
to strike their requests.
That's right.
Okay.
Does that,
Yep,
does
I
that
would-
sound?
That sounds good to me. Yeah, that's I think what we intended.
Okay, thank you. With that clarification, yeah, I'm happy to put together the order. I will try and get it so that Gordon and Haley can hear this. I'll try and get it to you by Friday. It may be Monday. I know we've got the board hearing on Wednesday, but I'll get that to you as quickly as I'm able.
Okay. Anything else from anyone there? Okay. Well, recess, and I appreciate everyone's participation. Thank you.
Thank you.
Thank you, John.
Thank you, guys. Appreciate your time.
Thank you.